fact, after a series of discussions with the government, found there are many provisions of the Act which may require a relook. And we have outlined it in this note.
Let's have a quick glance at the note so that then we can...
Your Lordship, please. So the first part of the note is about Your Lordship's order. I think we can look into that. Paragraph 11 is set out there. We're inclined to take this view for the following reason. Enactment of so-and-so has been rapid evolution of transport sector, particularly in the last few years, the emergence of new infrastructure, new arrangements of putting into place private transport arrangements. Interpretation must now duty take into account valid concerns of road safety bearing in the safety users. Then any change in position of law expressed in Mukan would undoubtedly have an impact on persons who obtain insurance relying on the law declared by this court and will be driving commercial vehicles with LMV licenses. A large number of persons will depend on the sector for earning their livelihood. Decision in Mukan has held the field for nearly 6 years, and the impact of the reversal decision at this stage, particularly in the social sector, is a facet which would have to be placed in balance with the policy of the government. Having regard to this feature, there is a view that the issue of interpretation referred to the Constitution bench with the referral order dated also should await a careful evaluation of the policy considerations, which may weigh with the government in deciding as to whether the reversal decision that obtains in so-and-so is warranted, and if so, the way forward that may be adopted bearing in mind the diverging interests, some of which we noted in the earlier part of the order. Hence, in view of the consequences which may arise by reversal, it would be appropriate the entire matter is evaluated by the government before this court embarks upon an interpretive exercise. Once the court is apprised of the considered view, the government, the proceedings before the Constitution can be taken up. This ministry has commenced the exercise of Amendment of Motor Vehicles Act, whereby Section 221 and Section 10 of the said Act are among the provisions sought to be evaluated. This ministry has identified many provisions from the MV Act which may require evaluation, including the said particular section. The entire process of amendment to the Motor Vehicles Act entails continuous consultation with stakeholders, especially the states, considering the fact that motor vehicles are vehicles by invention under List 2 and List of the Constitution of India in the 7th schedule. List 2 states in so-and-so serial number 57, then List 3 states in serial number so-and-so, etc. The views of the stakeholders are necessary for them to be incorporated in the draft language of the proposed amendment. To embark upon the process of amendment, the Ministry will be examining the possible repercussions of the amendment of certain provisions in the other provisions of the Motor Vehicles Act and rules framed thereunder to the state's exchequer and to the general public. Ministry has conducted a number of internal discussions, deliberated over the issues involved in the present matter in due reference, and in furtherance of the audited so-and-so, discussions entail examining the issues and the potential solution thereof with the officer of various divisions section of this ministry. On 2010, Ministry conducted a round of consultation with the stakeholders and the identified provisions, including the Department of Financial Services, General Insurance Council, and Insurance Regulatory Development Authority. 8th Ministry conducted another round of consultation with the stakeholders and identified provisions containing some matters specified to the states and union territories. In the process of seeking written inputs and comments from the stakeholders such as states and union territories and all the identified provisions, including Section 221 and Section 10. In order to thoroughly examine and evaluate the considerations that mentioned by the Honorable Supreme Court in paragraph number so-and-so, it is required to continue having the consultation with stakeholders and executing authorities. Said consultation is necessary for the Ministry to thoroughly comprehend and evaluate the issues entailed therein, as the implementation so-and-so comes under the purview of State Transport Department, concerned state, etc., etc. Then it will be pertinent to note that for the purpose of amendment to Section 221, Ministry ought to inter alia examine, deliberate the following consideration, in addition to the ones mentioned in paragraph number 1, namely, inter alia Section 7, 8, 9, 10, 183 of the Motor Vehicles Act ought to be examined for the possible repercussion of an amendment to Section 221. Inter alia Form 2 under rules so-and-so, Form 8 under so-and-so, etc. may require an appropriate amendment to align with the amended Section 221 and 10. The potential impact of the amendments to road safety, which inter alia entails examining the qualification of drivers, effect on road accidents, evaluation of the safety standards of light motor vehicles, reevaluation of training material for transport vehicles, etc. The above considerations ought to be deliberated upon state and other stakeholders. Exhaustive consultation stakeholders, the ministry shall be in a position to apprise the Honorable Court with respect to subject matter of the present petition. Therefore, I want to request to adjourn the present proceedings, sign and I. In fact, I had a series of discussions with the government, and rule section 221 and 10 has come up for very internal, intensified discussion. Therefore, the government thought that instead of going on a piecemeal amendment, let us take a larger view of the picture. That's why the matter stands. In fact, I impress upon the ministry to conclude all this before the next budget session sometime in February. But we have something on hand and the matter goes to Parliament.
Subject to hearing, of
Yes,
course,
yes.
the Learning Council. I mean, we are
Yes,
not
yes.
concluded. We'll, if necessary, we'll hear you. But if you all agree, we can pass this. We'll take on record your Roman 2 in our order. We'll just say that this is the exercise that the government of India is carrying out in pursuance of our order. We are not inclined to adjourn the proceedings sine die.
No, you lost that right. It may not be sine die.
It may
That's
not
the
be
request
fair,
has
it
come.
may not be fair to the
No,
insurance
I-
companies also, because
I-
they want some resolution at
I
some
agree.
point of
I
time.
agree.
So we can't tell them that, look, and because we are insisting, and that's the position of law, that until the constitution bench decides the issue, Mukund Devangan
Will hold the
continues to
field.
hold the field. Therefore, all tribunals, including their liability to pay, is governed by Mukund Devangan. So they must also have some clarity. So what we'll do is, on the 17th of January, we have listed the Arbitration Act Constitution Bench hearing, the similar thing, they were amending the act, etc. So we'll keep it on the 17th of January.
Fair enough.
We will expect that now the ministry must follow whatever it is doing with all expedition.
The only concern is about consultation with the state governments.
How long will it
how
take?
expeditious they can.
2 weeks. You have to
get
only
it.
tell the state governments, come back in 2 weeks. Because, if we keep this, sine die, then March, then April, then it goes to next year, I mean,
When your lordship has heard it substantially, all that
The-
time
the-
will go to waste.
The
If
secretary is
exactly, the longer the time that elapses, we will be ourselves a little hazier with, not at all.
The states just don't come on table for discussion.
We'll have to
You know,
enforce
the interests they would like to protect and so many invisible hands behind.
Mr. Would appreciate the exercise that you have envisaged in the note.
Yes.
In order to carry out, you may take 2 years also, and you may say that consultation is going on, response from a particular state A, state B has not come. So therefore, Unless we have a kind of
No,
a,
I entirely agree with that. I'm not saying that it should,
if the government pushes, the union government pushes, I'm sure the responses would come quicker. And if the governments, state governments and the union government are also conscious of the fact that the matter is going to come in a little while, then perhaps things may move a little quicker.
I would welcome your lordship's making observation. I hope in this exercise, state governments will also, you know,
I think that also.
Yes.
be able to, so that all the stakeholders will engage in expedition.
That's a good idea.
That's right.
In pursuance of the order of this court, in pursuance of the order dated 13 September 2023, the Union Ministry of Road Transport and Highways has informed the court through the Learned Attorney General for India that the exercise of amending the Motor Vehicles Act 1988, including the provisions of Section 2(21) and Section 10, is being evaluated, is, into inverted commas, sought to be evaluated. Stop. The exercise which has been carried out thus far by the union government is set out in the note which has been tendered by the Attorney General, which is extracted below. कोलन ये रोमन 2 में कॉपी कर लीजिए, नॉट रोमन 1. हेडिंग नहीं कॉपी करना है. स्मॉल 1, 2, 3, 4, 5 all the way up to the end of the note, up to small Roman 10. Next. We are not inclined to accede to the request made by the union government for adjourning the proceedings sine die. Full stop. This court is seized of the reference where the correctness of the decision of the three-judge bench decision in Mukund Devangan has been doubted. Full stop. Some clarity, some certainty, an element of certainty must be brought on the aspects which are raised in the reference. At the same time, since the union government is in the process of, at the same time, we do appreciate the stance of the union government that any exercise for amendment would involve consultation with multiple stakeholders, including the state governments, since the implementation of the provisions of the Motor Vehicles Act 1988 and the rules which are framed under it lies with the states. Full stop. In this view of the matter, we are of the view that the union government in the Ministry of Road Transport and Highways, we direct that the union government in the Ministry of Road Transport and Highways conduct the exercise, pursue the exercise which is sought to be conducted with utmost expedition, full stop. Since the state governments, since consultation with the state governments is envisaged, we direct that all state governments shall cooperate in the time schedule which may be laid down by the union, by MORTH, so as not to delay the proceedings any further. Full stop. The proceedings shall now be listed before this court on 17 January 2024, by which date, we expect that the consultation should be completed in its entirety and a clear roadmap of the further steps which the union government proposes to take should be placed before this court. Full stop. It needs to be clarified, though this is a settled principle of law, that though the correctness of the decision in Mukund Devangan has been doubted, the decision still continues to hold the field. That don't say though the correctness is, that during the pendency of this reference, the judgment of the three-judge bench in Mukund Devangan shall continue to hold the field, and all courts, tribunals, and authorities shall therefore act on that basis.
This order may be communicated to the state governments also.
A copy of this order
Yes.
shall be communicated to the chief secretaries of all the states, or as the case may be, the union territories,
Yeah.
for further dispatch to the competent arms of the states. stroke QTs.
But would your lordship only clarify this, that unless there is a clear roadmap, your lordship would proceed to hear the matter then?
Now we have said that they'll be give us a floor. We can't
It's obvious.
compel them to amend, but we have now
Correct.
virtually
In
said
fact-
that, look, give us a
In
roadmap.
fact, ultimately, my lord, in January, they may
They
very
will-
well come and say, we don't think any amendment is
We'll see at
required.
that time.
We don't know what they will do.
I don't
Probably,
think
I
that will
think-
happen.
That, because they also realize that there are instances. to-
No. In fact, I am getting
Body
periodic
is
reports
not-
from the ministry. We are continuing dialogue. I'm looking into it myself.